Oh, yes, definitely. And I was doing some research this morning working on this appeal, and the law is really clear. If you have an ex parte communication with a witness during trial, it is reversible error. So this error is, and what that means in the legal world is that's about as bad as it gets. That means it's reversible. That means that any conviction is going to be reversed because of this. So if they want to try and remedy this, they better hurry up and remedy it. And the state should really be thinking about that, because the state's duty is to preserve their conviction. So if they were to get a conviction, they have a duty to make sure that the conviction stands on appeal.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt.
The judge in Young Thug's RICO trial orders the rapper's attorney to jail for contempt.
How did you get that information supposedly from my chambers? Did somebody tell you?
You should have told me.
You got 5 minutes.
This happened after lawyer Brian Steele refused to tell the judge how he found out about a meeting between the judge, the prosecutor, and a state's witness. Steele's lawyer is here with what's next for him and Young Thug's trial. I'm Anjanette Levy, and this is Crime Fix. It was a crazy, wild day in court in Young Thug's trial. On Monday, it started with testimony from Kenneth Copeland, who goes by Little Woody. Copeland wasn't really into testifying, despite being given immunity by the prosecution. He spent the weekend in jail after refusing to testify on Friday. Copeland took the stand on Monday and let it be known that he wasn't going to do it.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
So after that, Brian Steele let the court know that he found out that Judge Earl Glanville, prosecutors, and
How you plead the fifth when somebody asks you how old you are? Oh my God. This whole court case has been a straight circus. The freaking judge throwing this lawyer into jail for contempt of court because the lawyer called out the judge for having an ex parte meeting without the defense being there, knowing good and damn well that's illegal. This is just a freaking circus, man.
Copeland, with his lawyer, met in chambers without members of the defense teams, including Steele, present.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
Can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any
Don't
of
worry
that?
about
This
it.
seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there. But Judge Glanville was furious that Steele found out about the meeting in chambers.
So
He was furious because he got a mole in his office. There are very few people in that chambers that heard that conversation, and somebody told the lawyer about it, the defense lawyer about it, and now the judge is pissed off that he got a snitch in his quarters. He got a mole in his quarters. He's not upset that the fact that the lawyers are calling him out that this was an illegal meeting, that this should probably be a mistrial or something. He's more pissed off the fact that somebody went behind his back and snitched on him and everybody else in that room to the freaking defense lawyer.
I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not influenced.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me
You don't have to. I'm
if
gonna
you don't tell me
continue.
who it is, I'm going to put you in,
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
go to
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
Oh,
You got 5 minutes.
got him.
Linville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because
The judge wants to know who he needs to fire tonight. He's going to call up Fannie. He's going to call up whoever he needs to. He will burn the midnight oil. He is determined to find out who in the hell snitched behind closed doors so he can fire their butts right now.
I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong.
No,
And
the
you're
meeting
asking-
was improper.
Listen, I told you the first time, and I'm not
Sir,
going to
I
breach
don't
that
wanna-
confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
The prosecutor on the case, Adrian Love, said there was nothing improper about what happened with this ex parte meeting in chambers regarding Kenneth Copeland being held in contempt.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Now, it seems like even the prosecutor thought that this could be an issue. Adrian Love asked that Steele be allowed to return to the courtroom.
We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
Now,
Yeah, because it's unfair that he doesn't have proper representation. He hired a lawyer, paid him a boatload of money, and the judge is finding him in contempt of court because he's mad that he got a snitch. Bump the fact that the judge is having communications without the defense being there. I don't know. He don't care about that. He just want to know who the snitch is, and he don't care what he's got to do. He's going to find out who this is, and it's kind of unfair to the defense. It's like, what am I supposed to do? You throwing my lawyer in jail for something that he should have been a part of in the first place.
later in the day, and I mean the evening after 7 p.m., attorney Ashleigh Merchant came to court to represent Brian Steele in this contempt matter.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
Okay.
And the judge never even denied that this happened in the first place. See, the lawyer, Brian Steele, he's going on and on and on about all these details. And the judge is like, you know what? You've got a lot of information to know about something you weren't a part of. Who told you this? He never once denied that this happened, denied that a conversation that Brian Steele said. He didn't deny anything. He just keep on asking, who told you that? Who told you that? So obviously, everything that Brian Steele is basically confirmed by the judge, because the judge is not denying any of this whatsoever.
He's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
Get him.
And
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
If you're anything like
Oh, she cooked him. Oh, she said, oh, no, okay, so you want to do that? Fine. You will be a witness. Can you imagine a freaking judge having to go into the witness stand to talk about something that he was a part of? Oh, my God, man. You see how crazy that this all is?
argument from Merchant didn't matter one bit. Judge Glanville held Brian Steele in contempt.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. And you'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024 at 7 p.m., subject to further order of this court.
Now, after the judge said that Brian Steele was going to have to spend his weekends in jail, Steele had just one request.
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you, and sir. I will, sir. If that comes to pass, you have my support. I will talk with our sheriff, and we may be able to make that work.
So think about what the Brian Steele, the lawyer, just asked for. He asked, okay, if I'm going to go to jail, can I sit in the same cell with my client, Mr. Williams? He's doing two things. Number one, he's getting protection. He is a lawyer that's probably never committed a crime ever in his life. He don't know nothing about no jail life. If he go to jail, who's to say that he's going to be in some bunkmate where somebody is going to do something crazy to him, bump him upside the head or whatever. But if he's in jail with his client, he can get kind of some protection from him. He know his client ain't going to do nothing crazy to him. He's trying to represent him in court, keep him from going to jail, keep him from his life being ruined. And here's another thing. You know, lawyers, they charge by the hour. If Brian Steele is in the cellmate, is in the cell with his same client, and he's working on this same case over the weekend, hour over hour, day after day over these weekends, he is going to charge for every single hour that he is with his client working on this case in freaking jail. So this is so clever. He's found two things for way to him to get paid and get protection while he's in jail at the same damn time.
Okay.
And this entire thing has turned Brian Steele into a hero of sorts among defense
Oh,
attorneys.
he a real one.
Joining me is Ashleigh Merchant. She is Brian Steele's lawyer. She's also the president of the Georgia Association of Criminal Defense Lawyers. So Ashleigh, talk to me a little bit about how you end up at the Fulton County Courthouse last night at 7:30 at night, representing Brian Steele in this issue, this contempt matter.
Definitely not how I imagined my day beginning or ending.
Right.
I was in a meeting and my paralegal came in and said, your phone is lighting up and Brian's in custody. And I said, oh my God, call me on my phone. I'm getting in the car. I'm driving down there. And, you know, I've served for many years as GACTL, as our association's contempt attorney, where we have attorneys that we dispatch if any lawyers are ever held in contempt. We call it Strike Force. So I'm a member of that. So I'm one of the lawyers that regularly would represent someone. But when I heard Brian was in custody, I had to go myself. And luckily, he's very loved in our community. And so many members of our team went down there and were there. And so we had a very strong showing of force, but it was definitely something I did not expect to happen.
You're a criminal defense attorney and you've done a lot of murder trials. Is this unusual? Because it sounds unusual to me that a judge would meet in chambers with a prosecution, you know, the star witness for the prosecution, the star witness's lawyer, and they'd all be there having a confab together without a member of the defense team present. Is that weird? That seems like an ex parte communication or something.
Right. And, you know, during my hearing, the judge is admitting that he had this ex parte communication. And it seems like that should be what everyone's focused on, not whether or not Brian is going to tell him who told him the judge had this ex parte. It just seemed like deflecting. You know, the judge was in trouble, got caught with having this ex parte hearing. And instead of admit to that and handle that, you know, when Brian brought it up, they're going to throw Brian in jail. It didn't make a lot of sense. But like you said, it's unheard of. These proceedings are supposed to be what we call adversary, where all the defense is there. The defendants, the defense lawyers are all supposed to be present. But instead, they chose to have this meeting without inviting any of the defense, without letting them know. And when they brought that up, the lawyer ends up in custody.
The only time I've ever heard of a defense attorney maybe being back in chambers meeting with a judge without the prosecution present or something like that happening is when it was like, oh, judge, we need to talk to you about funds we need allocated for an expert or something like that. If it's like a public defender case or something, you know, that's the only time I've heard of this type of thing happening. But this just sounds hinky. So what are you doing for Brian now? Because Brian, as of right now, is supposed to report to the jail Friday night to spend his weekend in the cell with Young Thug, getting ready for court and doing his time for this contempt that you argued that he shouldn't be serving.
Right. I mean, there's two huge issues there. The first, what we're doing is we are appealing it. So we're filing an emergency appeal. Thank God we have an emergency process in Georgia to appeal contempt orders. We believe the judges of the appellate courts will grant a bond. And so hopefully Brian will not have to spend his weekend in the jail. The worst part, though, is this trial is continuing. And so imagine, you know, we don't just work during the hours you see us in court. When we're in court, we are regularly working after hours. We're working at night. We're working on weekends. I have never tried a case where I didn't work all weekend. And Brian is a very good lawyer and he does a lot of work on his cases. So he's definitely working all weekend. You're taking a man from his office where he has computers, Westlaw, internet, all this stuff, access to the case file. And this case file's huge, and putting him in a jail cell where he's none of that. That the trial can't continue. I mean, it's just, it boggles my mind that anybody thinks that you could have the lead defense lawyer in custody the entire weekend and this trial continue unhinged.
Yeah, how is he supposed to have any kind of defense? His lead attorney, Brian Steele, is locked in a jail cell. How can you properly prepare for court? How can you properly prepare your witnesses or cross-examination or anything without any kind of resources because you're in freaking jail? It's like it's like there's some cooperation. It's like the judge is trying to fix this case in a way so there is no defense whatsoever. The prosecution office will just automatically win because there is no defense because the defense's lawyer is in freaking jail.
That defies logic to me.
So you're filing the emergency appeal. I mean, I would assume you expect to hear back about that within a day or so. Am I wrong about that? Or what's the process? What's the time frame?
Yes. Luckily in Georgia, when an attorney is subject to incarceration, the appellate courts respond very quickly. And what it's called is a supersedious bond. So essentially they issue a bond that kind of stays everything and says, wait, hold on, we're going to pause this. You're not going to have to go to custody. You get to go and do this appeal. And so it just pauses that while the appeal is pending. If we're successful with the appeal, then Brian never has to go into custody. Obviously, if we lose the appeal, he could still be forced to spend weekends in custody, but that would be down the road. That wouldn't be right now.
But then we have the issue of this big kerfuffle. I mean, this big mess, this big confrontation between the judge who seems very angry and really dug in on his position.
I don't think we have ever seen a case where a judge has been called out and cornered so hard and just completely going off the books about what he's supposed to do, he or she is supposed to do. And the fact that the judge is like, no, I don't care what y'all say. Y'all can appeal this, whatever. I am throwing him in jail for not telling me who snitched in my own doggone chambers. This is just absolutely bananas. This whole case was probably end up being a mistrial. And you would think the judge may need to recuse himself. But here's the thing. He's the chief judge in that courthouse. So you may have to take this to like a higher court or something, because the chief judge in this case can't even judge this properly because he's not being fair to both sides.
And Brian Steele, now the trial continues and they have to move forward. Brian Steele moved for a mistrial. That's not happening. Can this trial continue in your view and be tried fairly given what's happened? I mean, it doesn't matter if the jury didn't see this. It's something that is impacting the course of the trial.
I can tell you as a defense lawyer, nothing will affect your advocacy more than a judge saying, if you keep arguing and doing your job, I'm going to lock you up and putting you in handcuffs. Nothing will affect you more. And that's essentially what happened. Brian made an argument. He ended up in handcuffs. He ended up in the Fulton County Jail in the lockup for, an hour or so before the judge let him out. Nothing will stop an advocate in their tracks more than going to jail, because you can't do your job.
Yep.
And that fear has got to be in the back of everybody's mind in that courtroom. Every single defense lawyer, some of them, they may have kids they've got to go home to, and they can't go to jail. I mean, you think about the things that are going on in their minds. You want to be able to do everything you can for your client, but you can't do that if you're in jail.
But Ashleigh, can he go to the appellate court? Can Brian Steele maybe go to the appellate court and say, look at what happened? I mean, it's on video. That's not how appellate courts make decisions, but it could be filed as an exhibit and file something saying this is, some type of an appeal saying what is going on here, what happened is impacting this trial. Can that happen?
Oh, yes, definitely. And I was doing some research this morning working on this appeal, and the law is really clear. If you have an ex parte communication with a witness during trial, it is reversible error. So this error is, and what that means in the legal world is that's about as bad as it gets. That means it's reversible. That means that any conviction is going to be reversed because of this. So if they want to try and remedy this, they better hurry up and remedy it. And the state should really be thinking about that, because the state's duty is to preserve their conviction. So if they were to get a conviction, they have a duty to make sure that the conviction stands on appeal. And this is reversible error. So I don't understand why they're not jumping up and saying, give him these transcripts, give him what he asked for in this ex parte. They have a duty to preserve the record as well. Otherwise, they're just wasting the taxpayers' dollars and keeping people incarcerated while they try this case that they know is not going to stand up on appeal if there is a conviction.
Ashleigh Merchant, we'll keep an eye on it. Thank you so much.
So what do y'all think about this whole court case, man? Do y'all think that this should be a complete mistrial? The judge should recuse himself. Brian Steele should be free. Matter of fact, I think very recently the Georgia Supreme Court ruled that Brian Steele will not serve any jail time whatsoever. So that's a good thing. But still, the fact that the judge is not being held accountable or doesn't even want to admit his own wrongdoing for having this meeting without the defense lawyer being there or any part of the defense being there, that's just crazy to me. And he was willing to double and triple down and throw anybody in jail that wanted to oppose him and argue with him in this matter. He probably would throw Ashleigh Merchant in jail if he could. So y'all let me know what y'all think in the comment section down below. Make sure you like, share, subscribe to the channel. I'll catch you on the next one. Peace.